Take a quickie. Here's one that's confusing that I wish more law tubers would cover. Unfortunately, everyone keeps acting like it doesn't even exist. We keep seeing figures in the news taking guilty pleas having to admit to the crime in order to have their plea accepted. And that can cause problems later on if there are issues they have to appeal or if they have to give truthful testimony in another proceeding. The thing is, the Supreme Court ruled in 1970 that a defendant doesn't have to admit to the crime when pleading guilty. He can make what's termed an Alford plea. Henry C. Alford was charged with first-degree murder. The prosecutor agreed to a plea deal to second-degree murder so Alford could avoid the death penalty or life in prison. Alford entered the plea but refused to say he'd committed the act. In fact, he positively affirmed his innocence. The Fourth Circuit reversed it on the grounds that Alford made the plea involuntarily. Since he did it to avoid the death penalty, the guilty plea was a form of coercion. The Supreme Court ruled that the Fourth Circuit's reasoning was erroneous, the alternative being a situation where his assertion of innocence negated an admission to guilt, which was necessary for a guilty plea. They ruled, the standard was and remains whether the plea represents a voluntary and intelligent choice among the alternative courses of action open to the defendant. That he would not have pleaded except for the opportunity to limit the possible penalty does not necessarily demonstrate that the plea of guilty was not the product of a free and rational choice. Up to that point, it was considered that a guilty plea would be justified by the defendant admitting to the crime. Otherwise, it would be a plea of no contest, nolo contendere, which the prosecution would have been very unlikely to agree to. But the court ruled, an individual accused of crime may voluntarily, knowingly, and understandingly consent to the imposition of a prison sentence even if he is unwilling or unable to admit his participation in the acts constituting the crime. So it was exactly the opposite to what the Fourth Circuit reasoned. If Alford had been required to admit to the crime just to avoid the death penalty or life in prison, then that would have basically been a coerced confession, in violation of the 5th and 14th Amendments. And this is standing Supreme Court precedent. So then, why do we consistently see defendants being required to admit to the crime when pleading guilty? The only answer I've ever been able to get from anyone is basically, it's complicated. They go on about how there are a lot of complexities and nuances to our legal system. But this is a pretty clear-cut Supreme Court precedent. At the very least, Alford pleas should be the norm, even if there are exceptions. But everyone's acting like they don't even exist! I'm also baffled by criticisms of Alford pleas. Opponents claim they're coercive, but how? How is it less coercive to force them to admit to the crime? They also claim that it means you're incarcerating the innocent. Okay, so you force them to plead guilty, now they're no longer innocent? Or is this really just about sticking your head in the sand so you don't have to acknowledge that many guilty pleas probably are locking up the innocent? I just don't see any justification for forcing a defendant to be faced with the dilemma of entering a false confession to avoid facing harsher consequences. It's just another of those situations that makes me lose even more respect for our justice system.